now start with our first panel of today's session regarding the independence of the judiciary and the rule of law. I am to give a kind reminder to our speakers that you are each limited to 7 minutes. That was a kind reminder. That way your moderator will not have to interrupt you. So thank you for that. Let me please, as we rearrange ourselves for just a moment, welcome to the podium Miodrag Đorđević, President of the Supreme Court of Slovenia, please to the podium, and our panelists, Adrian Vazquez, Chairman of the Committee on Legal Affairs of the European Parliament, Sheikh Zaydan, the President of the Supreme Judicial Council of Iraq, Héctor Pérez Aguilera, President of the Constitutional Court of Guatemala, Holta Zaçaj, President of the Constitutional Court of Albania, John Pérez Brignani, Magistrate of the Supreme Court of Uruguay, and Małgorzata, Manowska, First President of the Supreme Court of Poland. Please welcome our panelists and our moderator.
Can we start?
Yes, please.
Yes. First of all, I would like to thank you for the invitation and for the honor to be present at that so distinguished and eminent event. As a newcomer, I would like first very briefly introduce myself. My name is Miodrag Đorđević, and my position is President of the Supreme Court of the Republic of Slovenia. I'm career judge sitting on the bench for 39 years, at the Supreme Court for 21 years. I'm dealing with commercial cases. I'm expert on insolvency law. I have PhD on insolvency. I'm member of INSOL, International Insolvency Institute. I'm help focal point. That means that I'm contact person to Council of Europe for education of legal professionals on human rights. Now it's better, okay. Thank you. So, I will start with my keynote speech. Ladies and gentlemen, I'm extremely honored to address you today in honor of the distinguished, I can say legendary jurist and judge, Justice Anthony Kennedy. It gives me a great pleasure to pay tribute to him, especially as a few years ago in Ljubljana, the capital of Slovenia, I had the privilege of meeting him in person. As we begin this discussion on the dependence of the judiciary, allow me to underline a fundamental truth. The rule of law cannot thrive without independent courts. Therefore, their independence should be respected, protected, and defended, not only by the state and social institutions, but by all those in position of power, for the sake of their own legitimacy. Emphasizing the independence of the judiciary and judges is of paramount importance, because it is a cornerstone for establishing and upholding the rule of law as a principle enshrined in our constitutions for the protection of human rights and fundamental freedoms. It is important to recognize that the independence of the judiciary is granted not only to protect the judges themselves, but also to ensure the integrity of the rule of law. With this in mind, it becomes clear that safeguarding the independence of the judiciary is not just a duty, but a profound responsibility, especially for those of us who work professionally within this system. Far from being a privilege of judges alone, independence is a right of citizenship that guarantees the impartiality of judicial decisions. The independence of the judiciary is a fundamental value and the cornerstone of any democratic society. The judiciary is the guardian, the bulwark of the rule of law. It is therefore imperative to strengthen the judiciary as a safeguard for the protection of citizens' rights against encroachments by the state and other special interest groups. As the eminent Slovenian professor Dr. Kranjc noted, a weak and dysfunctional judiciary means the end of the structured society and can only serve the interests of those who seek to evade the rule of law. In their endeavors, judges constantly strive to make the right legal decisions, to strengthen and shape the legal framework, thereby embodying the moral authority of society. However, a judge does not have moral authority by virtue of their position alone. Rather, it is through their diligent work, actions, and personal qualities that they achieve or establish moral authority. Judges must be aware of their responsibilities and act responsibly. Their ethical behavior, sense of justice, personal integrity, and professionalism are indispensable for making fair and equitable decisions. As Leonid Pitamic, a renowned Slovenian lawyer and legal philosopher, and the first dean of the Faculty of Law in Ljubljana aptly put it, we cannot create, distribute, or find justice if justice is not within us. A judge's commitment to society is paramount. They must have broad life experience and an open mind to understand the complexities of social dynamics. It is imperative that a judge should remain committed to supporting the independence of the judiciary as a whole, protecting it both individually and institutionally from any undue influence and control outside the purview of the law. In addition, a judge must have the unwavering integrity to rule according to his conscience and in accordance with the law, even in the face of possible internal or external pressures. Only a judge with sufficient courage can act autonomously, maintaining personal independence and resisting the influence of external factors. In this situation of the pressure, it is expected for judiciary to respond, especially in the situations when fundamental social values are at stake or when the rule of law requires support. In particular, the Supreme Court judges whose words have additional significance and impact are expected to speak out. The judiciary and the media are central and complementary institutions in democratic state governed by the rule of law. As an integral part of society, the judiciary recognizes that public criticism of the work of the courts is allowed. In a democratic society, the public is entitled to criticize the judiciary, and such criticism is seen as a legitimate means of ensuring accountability within the judiciary and of the judges themselves. It is incumbent upon the judiciary to take account of reasoned and substantiated criticism, however harsh or direct it may be. On the other hand, the judiciary must respond to unfounded, generalized, divisive, and politically motivated criticism, as well as to the respectful or inappropriate pressure. In a conclusion, I would like to emphasize that both the judiciary and the media must be independent in order to effectively serve the legal functions of the state. Only independent judges can administer justice impartially and in accordance with the law. Similarly, journalists, especially those who are trusted by the public, must operate independently to fulfill their role as watchdogs, providing an additional stronghold for the rule of law and constitutionalism, alongside the relevant institutions. Indeed, both the judiciary and the media should contribute to social order and peace and, as stated by the Slovenian jurist Dr. Merz, to the achievement of social consensus and social cohesion. Furthermore, whether as members of these institutions or as citizens, we should strive for a just world. Our actions should be guided by the well-being of people and the impact on their lives. As Mahatma Gandhi said, there is a higher court than court of justice, and that is the court of conscience. It supersedes all other courts. Thank you for your attention. Now I will give the floor to the other speakers. To this, you will do this. To the distinguished speakers and experts from other countries. My keynote speech was more general. I expect from the other speakers to be more precise or to express their experience or the problems in their own countries. So, and because I'm the moderator, I should kindly ask them to respect the time limit of the contributions for the sake of time frame of our panel and for the smooth running of the event. So I will give the floor, just a second, to Mr. Faik Zaydan, the President of the Supreme Judicial Council of Iraq. Please, the floor is yours.
Ladies and gentlemen, good morning. Is it okay?
No, it's off.
I prefer here. Ladies and gentlemen, good morning. I'm sorry my English is not good and Spanish also is not good. Therefore, I will speak in Arabic and I hope we have a good interpreter. Ladies and سيدات والسادة الحضور المحترمين صباح الخير. شكرا جزيلا للسيدات والسادة في الجمعية الحقوقية العالمية على دعوتنا للمشاركة في هذه الاحتفالية المهمة، والتي تعتبر فرصة سعيدة للقاء والتعرف على زملائنا القضاة والحقوقيين لتبادل الأفكار في المواضيع ذات الاهتمام المشترك عند الحقوقيين. وبهذه المناسبة أقدم التهنئة للقاضي السيد أنتوني كينيدي لمنحه ميدالية الشرف الممنوحة من الجمعية الحقوقية العالمية. اسمحوا لي قبل الدخول في أصل موضوع الحلقة النقاشية أن أعطيكم فكرة موجزة عن تاريخ القضاء في العراق. جميع المصادر التاريخية تذكر أن أول محكمة في التاريخ هي محكمة بوابة معبد دب لال ماخ سنة 2113 قبل الميلاد في مدينة أور جنوب العراق، حيث كانت المحاكمات تقام في المعابد لقدسية المحاكمات والوقوف في باب الآلهة، وتخصص إحدى بوابات المعبد للمحاكمات، وتحفظ نسخة من المحاكمات وتقرير عن الدعوة داخل المعبد. كذلك تشير المصادر التاريخية إلى أن أول وثيقة قانونية في التاريخ هي قانون الملك أور نمو للفترة من 2013 إلى 2096 قبل الميلاد. ثم أصدر الملك البابلي حمورابي قانون حمورابي المشهور، والذي يعتبر أول قانون متكامل بين الأعوام 1750 إلى 1792 منتصف القرن السابع عشر قبل الميلاد. وبموجب هذا القانون ظهر لأول مرة مبدأ الاختصاص المكاني للمحكمة في التاريخ، ووجد نظام التقاضي، المدعي والمدعى عليه والشهود. هذه الخلفية الموجزة لتاريخ القضاء العراقي، وعبر مسيرة تاريخية طويلة لا أود شغل وقتكم بها، انتهت إلى صدور أول قانون للسلطة القضائية المستقلة تماما عن السلطتين التشريعية والتنفيذية سنة 1963 في العراق، حيث تولى رئيس محكمة التمييز التي تعتبر هي المحكمة العليا في النظام القضائي العراقي رئاسة القضاء. لكن هذا الإنجاز المهم للقضاء المستقل تعرض إلى تغيير من قبل النظام الدكتاتوري في العراق الذي سيطر على السلطة سنة 1968، حيث ألغى هذه الاستقلالية وربط القضاء إداريا بالسلطة التنفيذية بوزير العدل، الذي يعتبر بطبيعة الحال هو جزء من الحكومة. لذا فقد القضاء جزء من استقلاله الإداري. وأنا شخصيا عندما كنت قاضي لإحدى المحاكم المهمة في العاصمة بغداد، قدمت بحقي أكثر من شكوى إلى رئيس الدولة، لكني نجوت بأعجوبة من إجراءات الرئيس القاسية في حينها باعتباره رئيس دكتاتوري. بعد تغيير النظام السياسي في العراق سنة 2003 تمكن القضاة من الضغط على الجهات المختصة والعودة لاستقلالية السلطة القضائية بشكل كامل عن السلطتين التشريعية والتنفيذية بموجب الدستور، وكما كان عليه الحال عام 1963، حيث تولى رئيس محكمة التمييز باعتبارها المحكمة العليا في العراق منصب رئاسة مجلس القضاء الأعلى الذي يدير القضاء في العراق بكل تفاصيله، سواء من الناحية الإدارية أو القضائية، ويتمتع بميزانية مستقلة. بفضل هذه الاستقلالية التامة تمكن القضاء في العراق من فرض مبدأ سيادة القانون رغم التحديات الكثيرة التي واجهتنا في هذه المهمة. على سبيل المثال، عندما كنا نتولى محاكمة الإرهابيين من تنظيم القاعدة فقدنا 67 قاضي قتل من هذا التنظيم الإرهابي، و179 موظف من العاملين في القضاء. لكن مع ذلك حقق لنا مبدأ استقلال القضاء التام عن السلطتين التشريعية والتنفيذية حرية اتخاذ القرار في القضاء العادي أو القضاء الدستوري، رغم انزعاج الكثير من الأحزاب السياسية والشخصيات النافذة من هذه القرارات. لكن بفضل استقلال القضاء الحقيقي لم نتأثر بهذه الانزعاج، واستمر القضاء في أداء مهامه في تعزيز سيادة القانون. شكرا جزيلا.
Thank you for your informative contribution. It was very interesting because we don't have a lot of experience with your country. Now I would like to give the floor to Héctor Hugo Pérez Aguilera, the President of the Constitutional Court of Guatemala. Please take the floor.
Buenos días a todos y a todas. Agradecemos los guatemaltecos el espacio que se nos brinda para compartirles reflexiones respecto a la importancia de la independencia judicial en el contexto político y especialmente de la independencia de los jueces de la justicia constitucional. La virtud del mundo político es el derecho constitucional y la independencia del juez constitucional es la garantía de la democracia. Para defender los principios consagrados en la Constitución de forma responsable, imparcial e independiente, proveyendo de certeza al ordenamiento político jurídico del país. Por ello, es muy importante reflexionar en torno a la independencia judicial constitucional como principio fundamental de la democracia sobre la responsabilidad que tal independencia conlleva y sobre los principios democráticos y republicanos que rigen el Estado constitucional de derecho en nuestro país, que como jueces constitucionales estamos llamados a resguardar y a garantizar. Guatemala es un Estado libre, independiente y soberano, que se organiza para garantizar a sus habitantes el goce de sus derechos y libertades, siendo su sistema de gobierno republicano, democrático y representativo. El ordenamiento jurídico guatemalteco regula la independencia de poderes en el artículo 141 de la Constitución, indicando que la soberanía radica en el pueblo, quien la delega para su ejercicio es sus organismos legislativo, ejecutivo y judicial, siendo la subordinación entre cada uno de ellos prohibida. En esta división de poderes corresponde al organismo judicial la importancia de impartir justicia de conformidad con la Constitución y demás leyes de la República. Por su parte, el artículo 203 de la Constitución Política de la República de Guatemala sobre la independencia del organismo judicial y potestad de juzgar refiere que los magistrados y los jueces son independientes en el ejercicio de sus funciones y únicamente están sujetos a la Constitución y las leyes del país. Asimismo, se establece que la función jurisdiccional se ejerce con exclusividad absoluta por la Corte Suprema de Justicia, así como por los demás tribunales que la ley establezca, tal como la Corte de Constitucionalidad. A su vez, se norma que ninguna otra autoridad podrá intervenir en la administración de justicia y que los tribunales de justicia, en toda resolución o sentencia, deben observar obligadamente el principio de que la Constitución Política de la República de Guatemala prevalece sobre cualquier ley o tratado. Por otro lado, el artículo 268 del mismo cuerpo legal regula la función esencial de la Corte de Constitucionalidad, siendo este un tribunal permanente de jurisdicción privativa cuya función es la defensa del orden constitucional, que actúa como tribunal colegiado con independencia de los demás organismos del Estado y ejerce funciones específicas que le asignan la Constitución y la ley de la materia. Los tribunales constitucionales deben defender su independencia frente al poder político, no solo por ellos mismos, sino porque su independencia constituye un derecho fundamental de todos los ciudadanos y de la democracia. En este sentido, la justicia constitucional constituye un elemento esencial para garantizar la libertad, la división de poderes y sobre todo el respeto de los derechos fundamentales, siendo su principal objetivo defender la soberanía materializada en la Constitución, elementos básicos de una democracia. Es de hacer notar que Guatemala fue el primer país de Latinoamérica en introducir en su ordenamiento interno un tribunal constitucional. La experiencia que se tuvo en la aplicación de la justicia constitucional regulada en las constituciones de 1945 y 1965, que permitió perfeccionar la materialización de la Corte de Constitucionalidad en la Constitución Política en 1985, siendo revestida de total independencia el elemento más importante para su consolidación, por lo que en esta última Constitución se establece como tribunal permanente totalmente independiente y autónomo como un órgano de control constitucional. La Corte de Constitucionalidad goza de independencia funcional, administrativa y económica. También los magistrados que la rigen y que la integramos. Una vez designados, somos totalmente independientes respecto del órgano que nos designó, libres para expresar opiniones sin que sean perseguidos por ellas, inamovilidad de sus funciones, derecho de antejuicio, la facultad de inhibirse de conocer casos específicos y de emitir votos razonados. Ha sido la independencia del Tribunal Constitucional la que ha permitido el mantenimiento del orden jurídico constitucional y la democracia del país. Un ejemplo de ello fue la sentencia del 25 de mayo de 1993, por la que se declaró inconstitucional el decreto que contenía las normas temporales de gobierno que pretendía centralizar en el organismo ejecutivo a los otros dos organismos del Estado, manteniéndose el orden constitucional frente a medidas de extralimitación de poder. La Constitución es garante de la independencia judicial constitucional y de manera que pueda desempeñarse la función de forma objetiva e imparcial, toda vez que no es objeto de la justicia la administración del poder, sino la restitución de los derechos fundamentales, dentro de ellos los civiles y políticos, que le hayan sido violentados a un individuo. Considero también importante mencionar algunos compromisos asumidos internacionalmente que refuerzan el principio de independencia judicial, como lo son los principios básicos relativos a la independencia de la judicatura, adoptados por el 7º Congreso de las Naciones Unidas sobre prevención del delito y tratamiento del delincuente, celebrado en Milán en 1985, y confirmados por la Asamblea General en el mismo año. Estos principios establecen que la independencia de la judicatura será garantizada por el Estado y proclamada por la Constitución o la legislación del país, debiendo todas las instituciones gubernamentales y de otra índole respetar y acatar la independencia referida. Asimismo, establecen que los jueces debemos resolver los asuntos que conozcamos con imparcialidad, basándonos en los hechos y en la consonancia con el derecho, sin restricción alguna y sin influencias alicientes, presiones, amenazas o intromisiones indebidas, sean directas o indirectas. El principio de la independencia judicial autoriza y obliga a la judicatura a garantizar que el procedimiento judicial se desarrolle conforme a derecho, así como el respeto de los derechos de las partes. De esta manera es posible indicar que uno de los principios básicos, si no fundamental, que garantiza el acuerdo y adecuado funcionamiento de la administración de justicia es el principio de independencia judicial. La Corte Interamericana de Derechos Humanos ha sostenido que uno de los objetivos principales que tiene la separación de poderes públicos es la garantía de la independencia de los jueces, siendo así que el objetivo de la protección radica en evitar que el sistema judicial se vea sometido a posibles restricciones indebidas en el ejercicio de su función por parte de entes ajenos. En consecuencia, este análisis sobre el marco normativo de la independencia judicial nos permite establecer que sin importar el contexto político que se viva, la justicia siempre debe ser impartida con total y absoluta objetividad e imparcialidad. En tal caso, Guatemala ha sido de conocimiento público los casos relacionados al proceso electoral recién celebrado, que fueron presenciados ante nuestro tribunal y presenciados por el mundo. Al respecto y para los efectos de la presente disertación, quiero manifestarles que como octava magistratura conocimos y resolvimos cada uno de los expedientes, observando en todos ellos los principios de objetividad, imparcialidad y sobre todo apego a derecho, manteniendo un mismo criterio y revistiendo de certeza jurídica la situación política del país con el fin primordial de salvaguardar el derecho de voto de cada ciudadano, así como la alternabilidad del ejercicio del poder establecida en nuestra Constitución. Como vemos, la justicia, en especial la justicia constitucional, no puede estar sujeta a ningún contexto político, pues de ser así, perdería su razón de ser, como lo es el de proteger a las personas contra las amenazas de violaciones a sus derechos. En nuestra calidad de jueces constitucionales, estamos llamados a respetar y a hacer que se respete la Constitución Política de la República de Guatemala y como tales continuaremos velando porque cada acción de la que tengamos conocimiento se ajuste a los cánones establecidos en nuestro ordenamiento jurídico a efecto de continuar preservando el orden constitucional. A manera de conclusión, es posible decirles que la independencia judicial es un pilar básico de toda democracia y sobre todo un derecho fundamental de las y los ciudadanos. Agradezco a cada uno por la atención brindada y ha sido un verdadero gusto poder compartir con ustedes este pequeño mensaje y un especial mensaje del pueblo guatemalteco y agradecimiento a todo el mundo por esa atención que tuvieron en estas últimas elecciones, de donde podemos decir salimos triunfantes y hubo alternabilidad en el poder y recientemente estuvo en Madrid nuestro presidente de la Constitución Política de la República de Guatemala, el señor Bernardo Arévalo, haciendo los acercamientos necesarios para velar porque nuestro país prospere y siga prosperando, aunado con los apoyos internacionales que lógicamente también necesitamos. Muchísimas gracias y que Dios los bendiga.
Thanks for a very substantiated contribution. Now I should excuse a little bit because I made one little omission and I would like to fix it. I would like, as a moderator, probably is expected to introduce a little bit the speakers, so I will do it now. The first speaker, Mr. Zaydan, is the president of the Supreme Judicial Council and also chief of the Federal Court of Cassation. He got the PhD on general law, which I found very important, with doctoral thesis on control of the constitutional judiciary on the constitutional limits among authorities. So it's very reliable and important speaker. The second speaker, Mr. Héctor Hugo Pérez Aguilera, He is presiding magistrate of the Court of the Constitutionality from 23 to 24, and also titular magistrate of the Court of Constitutionality elected by the Higher University Council of the University of San Carlos de Guatemala for the period 2021 to 2026. He graduated from the Universidad de San Carlos de Guatemala and got the PhD from the Universitat Autónoma de Barcelona, Spain. So I will turn on to the next speaker. The next speaker is Madame Holta Zaçaj, the President of the Constitutional Court of Albania. She got the scientific master's degree in securities and financial regulations at Georgetown University in the United States within the Fulbright program. At the moment, he is expert for human rights, children's rights, family law, banking law, and securities. A little strange combination, but anyway, promising. And I would like to give the floor to her, please.
Thank you. It is a little bit strange to hear about your CV in a certain way, but it's a little bit complicated. I started as a human rights activist and then as a lawyer, and then I moved to banking and securities because I thought that I should provide also for my family. The passion for human rights didn't pay much. Now is the great combination of all my experiences at the Constitutional Court. So anyway, I decided to speak seated because I think this will be a conversation. I mean, the principle of rule of law and independence of judiciary, it's not a novelty. We share, I guess these are the principles of universal value that we share basically among each other, no matter what language we do speak. However, coming from a country that was once part of the Eastern European bloc, probably I would highlight some historical facts and some challenges that are very peculiar, but nevertheless they share the same importance in terms of achieving when we can. So going back to having said that, we started at 1991. We didn't have the constitution. So we had the constitution before, but we didn't have the constitution until 1998. So for this period after the fall of totalitarian regime, we just have constitutional dispositions. However, at that time, the Constitutional Court was still the final interpreter of those terms, of those dispositions. And because of the fragility of democracy status in the country, the Constitutional Court tried and elaborated jurisprudence that basically interpreted these norms. Based on a very important principle that we had at that time in these dispositions, which was the Republic of Albania is a legal and democratic state. That's all we had. However, the court interpreted matters related to freedom of organization of political parties, superiority and binding nature of constitutional court decisions, organization and functioning of judicial power, conflicts of competencies between organs of public power, role of lawyers in democracy, right to private property as one of the main important issues that follow the transition period, right to fair trial. However, we have to say that the court failed to elaborate and define in a comprehensive manner the elements and indicators that determine the measuring level of respect of rule of law principle at that time. The Albanian Constitution of 1998, the one that we have now, provided among other principles that the law constitutes the basis and boundaries of the state's activity. During almost 30-year experience and history, Constitutional Court has influenced to a great extent the development of democracy by elaborating this notion in abstract control, and I would quote two very important rulings that we had from the court. stating that the rule of law principle implies ruling of law and avoidance of arbitrariness in order to respect and guarantee the human dignity, justice, and legal certainty. And another one, which are the main paramount decisions we have, is that the rule of law, being one of the basic principles in a democratic society, constitutes an independent constitutional norm. Therefore, its violation is sufficient basis for repealing a law on unconstitutional grounds. However, when it comes to individual complaints review, the court has been referred to the principle of rule of law also when examining, underlying that everyone's right to fair trial before an independent and impartial court established by the law derives and originates from the principle of rule of law. This right, the fair trial, should not be restricted artificially, and its implementation should not be impeded unreasonably. The individual's rights against the unlawful actions of other individuals or state institutions should not be protected only formally. Such protection should be a meaningful and effective one in reality. In this view, the constitutional jurisprudence has elaborated also the principle of separation and balancing of powers, adoption of laws in conformity with the Constitution, respecting of hierarchy of norms, activity of executive bodies based only on laws, guaranteeing of fundamental rights and freedoms, continuity and consistency of constitutional jurisprudence, principle of legal certainty, which is also the one that is most elaborated in individual complaints. I'm sure in many countries is. Within that principle, the legal certainty, the court has elaborated these elements: accuracy, clarity, and stability of the legal order, protection of legal expectation and non-violation of acquired rights, obligation to enforce final court decisions, avoidance of legal gaps, vacuums, prohibiting the application of retroactive laws except for the favorable criminal law, etc. In this regard, for the principle of separation and balancing of powers, the court has emphasized that three central powers should be exercised not only independently, but also in a balanced way. This is achieved by means of constitutional solutions that guarantee mutual control and a certain degree of balance between the powers without infringing or interfering with each other's competencies. Although these powers are separated in terms of functional autonomy and independence, in the exercise of duties assigned by Constitution, they are balanced by respecting, encouraging, supporting, and controlling each other. Independence of judicial power. This is one principle that the court has paid special attention as one of the main pillars of the rule of law. The court has elaborated as principles the fact that the court have exclusive right to render justice, and no other state institution or public official can exercise this function. It is this very function that actually determines not only the position of judiciary within the system of state power institution, but also the status of the judges themselves. Article 145 of the Constitution has provided that judges are independent and subject only to the Constitution and laws. And in line with the constitutional provision, interference in the activity of court and judges is prohibited. In the court's jurisprudence, the independence of judiciary is understood as substantial independence, which means the freedom of courts to render justice and decisions which are not based on the interest of any other branch of power. Structural independence, which is related to the way an institution is established or composed. Organizational independence, which includes the internal administrative structure of the courts. Financial independence, which implies autonomy in drafting its own budget and approval by Parliament, having adequate and sufficient funds to achieve its mission and its duties. And personal independence, which requires appointment of judges based on objective criteria, immunity, economic guarantees, career guarantees, the transfer and disciplinary system in place, all and equal for everybody. The court has considered also a number of cases pretending the violation of judiciary independence, such as the transfer of judges, exams of judges, salary of court clerks, salary of judges and prosecutors, organizational rules and authority of judicial conference and high judicial council, judges' leaves, authorities of court chancellors, administration of judicial power, criteria for the selection and appointment of the Supreme Court judges, etc. In addition, the independence and impartiality of judges and prosecutors in the context of fair trial is not a privilege, it's a duty. While impartiality refers to the judge's attitude in relation to the cases and parties involved in the process, independence implies not only a certain attitude towards the exercise of judicial function, but also a certain position or relationship with the other powers, especially the executive branch of power, that does not allow for interference. In this perspective, the court has elaborated the term independent considering the way the judges are appointed and their mandate's term. The guarantee of the term of office and unchangeability of that mandate is paramount in protection of the judge from the influence of political forces. Probably you have heard about the justice reform in Albania. I think it's, at least in the region, is a very well-known process. So although I mentioned so many principles that have been elaborated by the Constitutional Court, however, the Albania suffered from it was impossible to ensure independence, full independence of judiciary because of two main elements. The constitutional formula for the election of judges, composition and organization of self-governing bodies of judicial power, and the level of corruption in the country. Such situation required urgent and radical measures. In 2016, Albania adopted a justice reform package that aimed to guarantee the rule of law, independence of the justice system, as well as to restore the public faith in justice system institutions. But too much independence, you know, it's not always good, or too much independence still needs control. So that was the whole concept of the justice reform. In that perspective, new constitutional formula were approved both for the composition of self-governing bodies of judges and prosecutors, as well as on the procedure for selection and appointment of judges, aiming to detaching this process as much as possible from political actors, trying to ensure a transparent process based only on the candidate's merits. The new constitutional amendments provided also for re-evaluation of all current judges and prosecutors, including judges of Constitutional Court, which the process which was comprised the evaluation of assets, personal integrity, and proficiency. It should be stressed that this process was not an easy one. It led to a substantial reduction of judges and prosecutors, which caused delays in the court proceedings. The Constitutional Court itself was unable to render decision due to the lack of necessary legal quorum for almost 3 years. You can imagine what happens to a country without a Constitutional Court. I would like not to comment on it, but it's something that everybody can imagine. So many laws were passed, and no constitutional review was possible at that time. However, we have a fully formed bench now, and all the judges are selected and elected based on the new formulas. I would like to point out one last topic, which is the Rule of Law Index. Referring to the index of World Justice Project for 2023, Rule of Law in Albania is ranked on the 91st among 140 countries, which is 2-level decrease actually as compared to the previous index. So although all these achievements and all these, let's say, efforts, we still don't see progress. Well, I was curious to see the indicators for such ranking, and I saw inter alia that there was also a limitation of public power by the judiciary, measures, quoting, measures whether the legislative bodies have the independence and the ability in practice to exercise effective checks on and oversight of government. It was like pointing the finger, actually, to the Constitutional Court. And with many of you I've met also previously, we're facing a phenomenon in Albania, which is really the judicialization of politics. All the laws, almost all the laws, are brought to the Constitutional Court for constitutional review. And probably that was also part of this indicator when they tried to rank us to level below. However, I hope that that we can improve it and make it better. But probably the number itself shows it was considered within this indicator. Anyway, I don't want to go longer. I hope I'm within, so I know. I just want to finish by saying that the rule of law is one of the fundamental principles. It is actually the very cornerstone of justice, providing opportunities that support social peace, governance, and respect for fundamental rights. Nevertheless, the rule of law will always be evolving as long as the public powers, individuals, and civil society interact and promote the development of its dimensions. Thank you.
Thank you for your very detailed contribution. It was interesting, and because we are also from the region, it was interesting to hear the experience of the other country. So we are in the middle somewhere. We have 3 speakers more and half an hour, so I will give the floor to Mr. John Pérez Brignani, Magistrate of the Supreme Court of Justice from Uruguay. He is Doctor in Law and Social Sciences, representative of the Judicial Branch in the Advisory Council of Electronic Certification Unit, and also of the Regulatory and Personal Data Control Unit. He has qualifications on human rights, freedom of expression, and protection of journalists. So the floor is yours, please.
Muy buenos días. Es para mí un honor participar en este homenaje al ex juez de la Suprema Corte de Estados Unidos, el doctor Anthony Kennedy. Sobre la independencia del Poder Judicial. Sin un Poder Judicial independiente, realmente no puede hablarse de que hay Estado de Derecho, ni menos aún democracia. El Poder Judicial debe ser totalmente independiente, no solo de cualquier poder político, sino también debe darse la independencia económica que generalmente carece en casi todos los países. En mi país, por ejemplo, independencia económica no existe. Dependemos del Poder Ejecutivo y del Poder Legislativo, y generalmente la escasez de recursos es amplia. Ahora, la justicia, para que sea una justicia realmente efectiva, debe empezarse por el proceso de selección del juez y los procesos de calificación de esas, para que entren los mejores, no solo que entren los mejores, sino que se capacite con una mentalidad que puede ir evolucionando entre la jurisprudencia. Si una jurisprudencia que no avance con las medidas que van tomando las tecnologías y todo, no vamos a tener realmente una justicia. El juez es independiente de todo poder, pero debe también una responsabilidad, porque tiene que ser un juez que ejerza su ministerio con ecuanimidad y dentro del ámbito de la ley. Debe tener como norte que lo principal de la prestación del servicio de justicia es la persona. A su vez, el servicio de justicia debe ser absolutamente transparente, porque la transparencia es lo que le va a dar legitimidad. se advierte muchas veces que el poder es cuestionada la legitimidad a veces del poder judicial porque realmente no se comprende o no se difunde realmente la tarea que realmente cumplimos. El poder judicial tiene una amplia esfera de actuación que no se ve y que tiene sumamente importancia. Por ejemplo, por un poder judicial independiente operan hasta calificadoras de riesgo y le dan préstamos a los países. Eso, sin embargo, no es visto cuando se le dan los recursos al poder judicial. Es importante también, en mi país no existe tribunal constitucional, nosotros tenemos todas las funciones. Es importante también que los jueces de primera instancia, de tribunales, cada vez se abran más la mente a aplicar los puntos constitucionales, las normas constitucionales a los casos concretos. Lo ideal es proteger, la función del Poder Judicial es proteger a la persona. Es la última barrera contra el avasallamiento de los restantes poderes del Estado. A su vez, opera como un contrapeso de los restantes poderes y para ello debe operarlo con ecuanimidad sobre todas las cosas. Bueno, muchísimas gracias.
Thank you for your contribution. Now the floor is on Małgorzata Manowska, as I can recall correctly, the first president of the Supreme Court of Poland, adjudicating in the civil chamber with PhD in legal science at the Institute of Civil Law at the University of Warsaw. So please.
Dear colleagues, time is running, and to begin, let me express my thanks for the invitation to this conference and the opportunity to address you. The topic of this panel is independence of the judiciary and the rule of law. Contrary to what it might seem, this topic is certainly not easy. When assessing the status of the rule of law, two aspects should be taken into consideration. The first one refers to lawmaking. For the concept of the rule of law to be assessed, it is important to know what kind of law is being enacted. We know many examples from the past when laws violated human rights or even led to the discrimination or extermination of certain social groups. Therefore, in assessing the status of the rule of law, it's vital to know what kind of law will be enacted and then observed. This in turn leads us to the question, who is entitled to claim that the enacted law is unjust? In cardinal matters, of course, modern legal systems have mechanisms for assessing the constitutionality of specific provisions of law. What raises doubts, however, is the assessment of the quality of the law with reference to more common issues of lesser importance. The second aspect of assessing the status of the rule of law is how the law is applied by courts. I am the judge. Taking into account that courts exercise a review of administrative decisions, all cases may ultimately end up in court anyway. The courts are also responsible for imposing ultimate understanding of the law. Justice Oliver Holmes once said that the law is what the courts say it is, and his words remain relevant today. His remark, although formulated with reference to common law, is also somewhat applicable to countries with statutory law. The courts are categorized as the third branch of government by virtue of their function of final adjudication of disputes and their function of reviewing administrative decisions. The authority, of course, has a clear advantage over the executive branch and even the legislature. Although the courts do not review the work of the parliament, it is up to the courts to decide about the content of the legal norms that are ultimately applied. Undisputably, the judiciary, which engages in the administration of justice and has a controlling function over public authorities, should be endowed with the attribute of independence. This ensures that the law will be applied in a way that is free from pressure and undue influence from other authorities. On the other hand, however, a total lack of control over judges creates the risk that the rule of law may turn into the rule through law, or even the terror of law, with the third branch of government turning into judiciocracy. This was pointed out as early as 1787 by a writer nicknamed Brutus in America, who said that the lack of constitutional control over the judiciary would turn the Supreme Court into a tyrant and oligarch, thus overwhelming the other branches and distorting the tripartite balance of powers. With such a position of the judiciary, judges may turn more towards power than law when making their decisions. In other words, they will be more interested in exercising power than in adjudicating cases. They will become Caesars. Brutus asked, "Isn't it the same case that judges in their long robes have the same thirst for power as congressmen in their long coats?" The issue at stake is not about judges violating the law, but about manipulating the law. Indeed, before a court applies the law, it must first interpret it, for instance, carry out a thinking process to clarify the content and meaning of a particular legal provision. The interpretation should be consistent with the spirit of the legal norm. Sometimes, however, excessive judicial activism distorts the sense of the legal norm, giving it, in fact, a completely different meaning. In Poland, legal scholars developed the concept of a rational and lawful judicial decision that has been accepted for a long time and plays a fundamental role in judicial practice. Jerzy Wróblewski, the author of this concept, emphasized that interpretative restraint in the sphere of public law implemented through the primacy of linguistic interpretation is the best guarantee of the rule of law. Wróblewski's concept claimed as an objection to the practice pursued by part of the Polish judiciary during communist rule, when functional interpretation was abused and courts invoked vague phrases or even communist axiology in their rulings. There were well-known cases when citizens were expropriated without adequate compensation so that the communist government in Poland could make investments. There were also cases of judicial crimes during the communist period, primarily during the martial law of 1981 to 1983. As we know, times have changed, and fortunately, communism has become a thing of the past in Europe. Does this mean that Wróblewski's theory is also a relic of the past? Well, of course it's not. Modern times have brought risks that make this concept continuously relevant for three main reasons. Firstly, rapid social change, development of the civilization, and the needs of commerce have triggered a crisis in the formula of statutory law, which has now kept pace with these developments. This in turn means that the functional interpretation plays an important role in the application of the law, and this can sometimes lead to the degeneration of the legal norm being interpreted. Secondly, contrary to what it might seem, in addition to its undoubted benefits democracy poses, certain risks related to the sense of universal freedom. The right to freedom of expression should be seen as a basic human right. However, I personally follow the so-called old school of judging, which promotes the idea that this right must be limited when it comes to judges. A judge should not speak out in the mass media, even on important social issues. A judge should not reveal his or her political preferences or views. Indeed, a judge speaks through judgments and their reasons. In order for the rule of law to be preserved when the law is being applied, it is important for the judge to believe that they respect the law, including the citizens' right to a court, and above all, to know that they are perceived by citizens as impartial. The third reason why the rule of law may be under threat in the process of the applying the law is the influence of the media and the community, sometimes even turning into pressure. Personally, I have been a judge for 30 years, and I have witnessed this phenomenon, which has unfortunately intensified recently. The common thinking is, the majority is right, and if you think otherwise, you will be criticized and stigmatized. This phenomenon encourages judges to interpret a legal norm in a way that remains within the mainstream of commonly held views and attitudes. Indeed, to stand up against this phenomenon, a judge must show a great deal of mental toughness. But on the other hand, democracy and the rule of law cannot restrict people's right to have their own opinion and to express it without fear. In the case of judges, this is achieved through their rulings. In conclusion, let me say that in my view, the challenge for the rule of law in modern democracies lies in maintaining a mutual balance of competences among the different branches of government. This applies equally to the courts, which rule on the basis of the law and within the limits of the law without imposing a particular vision of reality through law. In the case of the courts, however, we face the eternal dilemma: who will judge the judge? The idea, however, is not to have an authority that would exercise some kind of superpower over the three branches of government. Instead, it is about promoting the idea that judges should assume an attitude of restraint in their interpretation of the law, in their statement, and their influence in the community. I believe that the rule of law can be maintained not through institutional influence, but through the social sciences, such as sociology, pedagogy, or psychology, and through shaping the right attitudes. Thank you for your attention.
Thank you for interesting contribution. With one remark. From my point of view, the judiciary is not the third branch of power, but one of the three equal and equivalent branches of power. And the other remark is, the difference is we are the judicial professional, but not political powers. So, but we are also one of the powers. Thank you. And the last speaker who joined us recently, is Mr. Adrian Vasquez Lazara, the chairman of the Committee on Legal Affairs of the European Parliament. So I will kindly ask him to join us. No, he is not here? He is not here. Okay, then my mistake. So I would like to thank all the speakers, the distinguished guests, for their valuable contributions, and also to the audience for the attention. But we are not yet out of time, so we have some time for for the comments or the questions. So please, now the floor is yours. It's also, if some of the speakers wants to comment or to add something, now it's the time. Only 5 minutes. No? Okay.
I just want to thank you everybody for your contributions and I think we need to make a break in order to start the new panel 11:30. But I would like to make a question for you particularly, and also for you in Iraq and Poland. So first thing is international opinion is not always probably well informed. And sometimes we hear doubts about the independence of the judiciary, both in Poland and Iraq. And I would like to, what could you tell us about, for example, some scenarios where you showed independence regarding the legislative or the judicative. So it's something where you could explain that you were controlling the powers, either executive or judiciary. And the same for you, not with Tusk. Tusk is, but with the former government, where can we see these events of independence? Thank you.
شكرا جزيلا. الحقيقة استقلال القضاء في العراق احنا نعتقد انه استقلال حقيقي عن السلطتين التشريعية والتنفيذية، وهذه الاستقلالية كانت واضحة بشكل خاص بعد 2003 في كل الأزمات السياسية اللي شهدها البلد على أثر الانتخابات التي أجريت. على سبيل المثال مؤخرا كان هناك صراع كبير جدا بين القوى السياسية على من هي الجهة التي لها حق تشكيل حكومة على سبيل المثال. فكان القضاء الدستوري موقف شجاع وأصدر قرارات لم تعجب الكثير من القوى السياسية، لكن بالنتيجة هي قرارات نافذة كان لها دور مهم في تشكيل الحكومة الحالية. كذلك كان أحد الأقاليم أو الإقليم هو الوحيد الموجود في العراق، إقليم كردستان، يصدر النفط بدون موافقة الحكومة المركزية. القضاء الدستوري أصدر قرار وأبطل جميع هذه العقود وألزم حكومة إقليم كردستان في شمال العراق بأن يتم تصدير النفط من خلال الحكومة المركزية، وهذا أيضا أزعج الكثير. قبل حوالي شهرين أثيرت عدد من الاتهامات على رئيس البرلمان العراقي مثلا، والقضاء العراقي القضاء الدستوري أقصد أصدر قرار بعدم أهلية رئيس البرلمان أن يبقى بمنصبه رئيس البرلمان العراقي، وألزم البرلمان العراقي على انتخاب رئيس جديد للبرلمان. هذا دليل على قوة واستقلالية القضاء بصرف النظر عن رأي السلطتين التشريعية والتنفيذية. شكرا جزيلا.
Jako sędziemu nie wolno
wolno wdawać się w dysputy polityczne, nie będę więc oceniać działalności rządu ani tego, ani poprzedniego.
As a judge, I cannot be politically involved, and and I cannot say any political opinion about the former government, neither the present government in Poland.
Historia wskazuje, że rządy się zmieniają, a sędziowie powinni być niezawiśli i niezależni zawsze.
The history shows us that the governments are changing, and the judges should always be independent.
Niezależność i niezawisłość wyrażają sędziowie w Polsce za pomocą oczywiście swoich orzeczeń i ich uzasadnień.
Their independence of judges in Poland is shown in their rulings and the reasoning of the rulings.
I oczywiście pojawiają się różne opinie na temat praworządności w Polsce, w szczególności jak chodzi o postępowania dyscyplinarne przeciwko sędziom.
And there are some opinions about rule of law in Poland, especially concerning the disciplinary proceedings on judges in Poland.
Jak obejrzałam statystykę postępowań dyscyplinarnych i takich postępowań, które mogłyby być uznane za motywowane politycznie, były 3 i skończyły się niczym, czyli nie dotknęły sędziów.
When I reviewed the statistics of those proceedings, disciplinary proceedings, there were 3 of them which one could only 3 of them which one could perhaps say that it was politically motivated, but the 3 of them, all 3 of them, ended without any consequence for a judge.
Sędziowie w Polsce od 1989 roku mają przez cały czas pełnię niepodległości, niezależności, a najlepszym przykładem jest to, że słychać ich na świecie i w Europie bardzo głośno. Dziękuję.
Since 1988, Polish judges has total liberty, and the best example of that is that Polish judges are perfectly heard, their voices are perfectly heard all over the Europe. Thank you very much.
We can conclude. Thanks once more.